Hello, everyone, and welcome. Thank you for joining us today in our discussion and overview of the American Data Protection and Privacy Act, otherwise known as the ADPPA. What's to come and how it will impact you working in this life science sector. During this discussion, we plan to address the questions that you might all be asking yourselves: the why, who, what, when, how it pertains to you and your company, and how we here at MyData-TRUST can support and assist you throughout this process. Let me start first by introducing who we are. My name is Julie Liambotis. I am a Data Protection Officer and the U.S. Director of Operations here at MyData-TRUST. I have a background in clinical life science industry and have been working here for over 20 years in different roles and functions spanning clinical to operations. Joining me today is my U.S. teammate and colleague, Carvel, who will be presenting alongside me, and our data protection lawyer, Manon, who will be monitoring the chat and assisting in answering questions during the Q&A session at the end.
So hello, everybody. My name is Carvel Brown. Welcome, and thank you for attending. A little bit about myself. I'm a data protection officer for MyData-TRUST. My background, I have a doctorate in pharmacy with 11 years of experience as a pharmacist, including clinical trial research.
Hello, welcome everyone. My name is Manon. I'm a data protection lawyer. I'm a data protection officer and US specialist located in Belgium, and I will be monitoring the chat during the presentation. Thank you.
So, for those of you who don't already know us and who we are, MyData-TRUST, as we like to refer to ourselves as MDT, is a company that specializes in data protection and privacy and is exclusively dedicated to the life sciences. Since its creation in 2017, MyData-TRUST now has more than 100 experts comprised of legal, operations, and IT, with offices located in 5 countries, soon to be more as we continue to grow. MDT is a global full-service provider, and we support customers like yourselves to implement the different data protection regulations worldwide. Today, thanks to our US experts and US presence, we will provide you with an overview of the potential future impact that ADPPA will have in your industry, in our industry. In the top picture on the right, just so you can see which countries have already implemented data protection laws, most common the EU GDPR, the UK GDPR, the Swiss DPA, China's PIPL, and the LGPD in Brazil. The ADPPA is soon to join this list. Below is a picture of our current US team located here in San Francisco.
So let's dive in and talk about why we are here today. So why we're here to talk about the data privacy legislation in the US, which is considered long overdue. The majority of Americans are concerned and confused about how their data is being handled, and they want government oversight. There is overwhelming bipartisan support for a national data privacy law, meaning a law is coming. The House of Representatives has released a first draft of the American Data and Privacy Protection Act, the ADPPA. And based on this draft, we know what we should anticipate in a finalized bill. Please note that the ADPPA largely draws on concepts from the EU General Data Protection Regulation, the GDPR. So as a refresher for our US colleagues and for our foreign attendees, here is a simplified review of the US legislative process, including the current status of the ADPPA. As I mentioned, the first draft has been finalized and is currently under revision by the US House of Representatives. After this is completed, then a proposed law will move to the Senate for approval and possible modification. The final step after the Senate would be signature by the President.
So, now that we know why we are all here today, let's talk about who this law will impact. ADPPA will apply broadly to organizations operating in the US. This federal law will apply to businesses that fall under one of 3 categories: those that are subject to the Federal Trade Commission Act, in short, the FTCA, or to nonprofits, or to common carriers. The ADPPA will impact covered entities, businesses like yourselves that determine the purpose, why, and the means, how, for collecting, processing, and transferring covered data. Covered data is the key term here. An example of this in the life sciences include companies that conduct human subject research or clinical trials. Another example would be companies that maintain health data that are not covered under HIPAA, so non-HIPAA covered entities, such as a tech company collecting real-time physical health data from mobile applications or wearable fitness trackers. To name a few, Fitbit, Apple Health iOS, apps for fertility, medication reminders, the list is long. These will fall under the scope of the ADPPA, which is not currently the case for HIPAA. The questions that we need to ask ourselves is when I collect clinical data, what should I do? How should I proceed? What are the processes I need to put in place to be compliant? And what is the impact? The term cover data, as you can see here above, is any information that directly identifies or links an individual or their device, with special emphasis being placed on protection of sensitive cover data and personal information. Pseudonymized data, referred to here in the GDPR, is the same concept as coded data, which is in this particular new act. Clinical data, which includes pseudonymized data, falls under the scope of the ADPPA because of its identifiability. So in practice, cover data would be your government ID numbers, social security numbers, private communications, and emails, or other information that could be related to subjects like children under the age of 17. So now let's see who ADPPA does not excludes. I apologize. Who excludes? It excludes data that is de-identifiable data, which is the concept synonymized into anonymization in the GDPR. It also excludes employee data. Unlike the GDPR, employee data is not covered in this new ADPPA. Lastly, it excludes public available personal data. So now, how will this impact me or my company? First, you can expect that data subjects will have access to new data processing rights. The 4 rights that will exist under this new law, which is similar to the GDPR, include the right to access, the right to correct, the right to delete, and the right to data portability. The Federal Trade Commission may have authority to apply exemptions to some of these rights on a case-by-case scenario. Also, when processing sensitive data, we can expect that the ADPPA will enforce an opt-in principle. The opt-in principle is synonymous to the concept in GDPR that we consider as consent. Different from the CCPA, the California Consumer Privacy Act, who enforces an opt-out principle, meaning that the CCPA does not ask for consent when processing data. This new opt-in principle is similar to the GDPR in that 1, it strengthens and protects the data, and 2, it classifies certain categories as data as sensitive. The important thing to note here with regards to the life science sector is bolded in the first 2 bolds above in this slide. 1, health data, biometrics, genetic data, mental health data, data revealing sexual orientation. Other sensitive data will also be included, such as your social security number, your geolocation, private communications, and information with regards to children. What's important to note here is the last 2 bullets, which is different from the GDPR. The ADPPA is more extensive and classifies government issued identifiers, financial information, and private photos and videos as sensitive. Even if you are compliant with the GDPR, there will be additional categories that will require extra compliance measures. Now, unlike the GDPR and the CCPA, this ADDP Act refrains from classifying data which disclose race, ethnic origin, and trade union membership as sensitive data. Initially, this was in the Act, however, it was removed, and let's hope to see if it's returned back once the bill is finalized. Excuse me, technical glitch. Another item to consider is we will anticipate that the ADPPA will implement officers. For companies that have more than 15 employers, they will have to appoint one or more qualified employees as privacy officers. Also, they will have to have one or more qualified employees as data security officers. The qualification process for this is still yet to be determined. MyData-TRUST solutions include to implement a data privacy program and a data security program, and to help facilitate organizations in their ongoing compliance with this Act. We also need to talk about the enhanced data protection for children. Targeted advertising is prohibited for children under the age of 17. For those children between the age of 13 and 17, you may not transfer cover data to third parties without affirmative consent. As you can see here, children's data is protected as sensitive data. And lastly, we can expect new compliance measures with higher standards for large data holders. Large data holders must conduct biannual audits to ensure compliance with all the applicable laws and submit audit reports to the FTC upon request. Large data holders, for those of you who need a quick definition, are those who have a gross annual revenue of at least 250 million, and also who collect large data, collect and process data to large individual numbers, such as 200 million, and so forth. Carlo, you're on mute. Sorry to interrupt.
Now that you have a good idea about what to expect, let's talk about the penalties that will be implemented for non-compliance. But first, we need to understand how the penalties will be enforced and the enforcement strategy proposed. There will be 3 enforcement strategies: one at a national level, one at a state level, and one at an individual level. At the national level, the new law will be enforced by a creation of a new Bureau of Privacy, which will be a division of the Federal Trade Commission, the FTC. One thing to note here is that the new Bureau of Privacy will have the ability to create technical compliance programs to help guide businesses to adhere to the new law. At the state level, state attorney generals and state privacy agencies will be able to enforce the law via lawsuits. And lastly, at the private level, individuals and private entities may bring civil lawsuits against organizations and receive compensation for damages. One thing to note here about this enforcement strategy is, unlike the others, this would not take effect until 2 years after the start date of the proposed law. So, unlike GDPR, there are no statutory damages provided for in the ADPPA. Instead, it actually goes a bit further, because failure to comply with the ADPPA would be treated in the same manner as other compliance failures under the FTC. These would include penalties that, after adjusted for inflation, could total $46,000 per violation for anything that the Bureau of Privacy considers unfair and deceptive acts or practices. The Bureau may also seek monetary relief for conduct considered to cause injury to consumers. And finally, the Bureau may conduct investigations to compile information to report to Congress and the general public. Finally, as we already discussed, states and individuals can initiate lawsuits against an organization for non-compliance. So the next question we need to address is when to proceed to initiate compliance with our companies. Please note that the new law is expected soon. The exact time, we don't know, but a finalized bill should be anticipated, and please know it is coming sooner than you think. Please be ready. The House of Representatives wanted to have the first draft finalized within 6 months, and we're already past that deadline, and so we can anticipate that this will be moving forward quickly. So Republicans currently want the law to supersede state laws and to eliminate individual civil lawsuits. What does this mean? It would eliminate the power of states' current data privacy laws. Democrats, on the other hand, want to keep state laws enforceable as well as individual civil lawsuits. What does this mean? Companies would need to comply with both the ADPPA and current state laws. Democrats and Republicans reached a compromise in the ADPPA draft that allows civil lawsuits and would allow ADPPA to supersede state laws. Once brought to a vote, this draft is expected to easily pass the House of Representatives. So although there are differing opinions, the majority of the legislation has bipartisan support and is unlikely to change. Things to definitely expect include subject rights, processing of sensitive data, appointing data privacy and security officers, and enhanced protections for kids, as Julie has already discussed, and there are going to be other items included as well. The areas that we might see some adaptations to the proposed law, as we already discussed, would be the ability for the ADPPA to supersede state laws and the removal of the civil lawsuits as an enforcement strategy. So one additional item that we need to address that is mentioned about the ADPPA is for any attendees involved in human resources. The ADPPA's current version will not affect the new processing of employee data required in California's new CPRA law. The CPRA law is only a few months and is initiating in January of 2023. So please do not assume that the new ADPPA law will supersede the CPRA regarding processing employee data, because it will not. If you are not prepared, MDT can help facilitate compliance with the CPRA. So what would be the next step? How do we proceed? The ADPPA does not come with an implementation guide. We already experienced major confusion, particularly in the life science sector, where we're processing sensitive data when Europe's GDPR law was enacted without any guidance. We learned that you cannot rely on your IT team or rely on your legal team alone to implement the new data protection laws. You need both the IT team, a legal team, as well as an operational team to facilitate their coordination. This is what MyData-TRUST does, and the reason why we created our organization. MyData-TRUST has a legal team, we have an IT team, and we have the operational team to comprehensively assist companies to comply with the new data protection laws.
So, if you recall, in the beginning of the discussion when I asked, how can we, MyData-TRUST, support and assist you throughout this process? So in summary, we, MyData-TRUST, can operationalize and assist you with creating standard operating procedures and policies for your company, create privacy notices for your websites, ensure that your contracts and service providers are compliant, build a data privacy program and a data security program for your company, and implement privacy by design and optimizing the data minimization principle. We can also customize services based on your organizational needs. Which brings us to the conclusion of this discussion. And what that means is you probably have more questions, or you will have more questions, and you may want more information. So please come and meet our team. We'd like to invite you and take the opportunity for you to join us on our MyData-TRUST tour. This will take place in February and March throughout the US. We will also be running some tours throughout Europe at a later date. Dates are still to be determined, but they are coming soon. So please follow us for updates on our different social media platforms. Do not hesitate to contact us directly for any additional information or questions. Thank you guys so much for attending today and listening to us, and we hope we can support you in your upcoming future needs. We are going to open this up now to a Q&A panel. We have Manon in the background who has been monitoring our chat. And once again, we really thank you for listening and participating, and we hope to work with you guys soon.
Thank you, Julie. So here, I am here for answering your questions. So I can see there is a new one. So is there any requirements for privacy notices? So yes, there is some new requirements, and especially privacy notices needs to meet a certain standard, and especially ADPPA mandates privacy notice to disclose whether data is transferred to or disclosed or processed in, stored in, or even accessible to China, Russia, Iran, and North Korea. So this is very important. I have another question. Should the DPO be a lawyer? So not especially, because legislation does not appear to prescribe specific training or certification requirements, but rather encourages the idea that they must have the knowledge to fulfill their role. So there is no such specificities, but there is more like a general designation requirement. So it can be a lawyer, but it doesn't have to be a lawyer. It's someone who knows what he's talking about. There is another question about anonymization under ADPPA. It is really the same as GDPR, meaning anonymize means nobody anywhere as the key lock to unlock the data source. So as far as I know, in the text, there is no mention, no reference to anonymization, neither to pseudonymization. So this needs to be clarified. But in my opinion, anonymization should have the same signification and same meaning as in the GDPR. So it means that you can no longer identify the individual, and in the opposite, de-identify. De-identify is the term they use. They prefer de-identify. We prefer in the GDPR to talk about anonymization, and pseudonymization in the GDPR will be more like the cover data in the federal law. But those are quite similar meaning. They just prefer to use other terms.
As we continue to wait for a few more questions, the following slide has our contact details. So again, when you leave this presentation discussion and you think of other questions that you may have that pop up, please, again, do not hesitate to contact one of us and we will send you to the appropriate contacts to follow up. Again, my name is Julie. I'm the Data Protection Officer here in the US, and my information is up on the screen. We have Carvel here, who's also located here in the US on the operational side, and his contact information is here. And we have Manon, who is the data protection lawyer and US specialist here, and her details are below. So please, once again, do not hesitate to reach out to us if you have questions, concerns. We'd like to get you ready. We'd like to get you ready as soon as possible so that you are prepared. And once again, we invite you to join us on our tour in early Q1, February and March, and meet us in person, meet our team, ask your questions, let's collaborate. And once again, we look forward to working with you in the future.
Thank you, Julie. There is another question coming up, so quickly answering this one. So is there any requirement for data transfer outside of the US, like similar to the GDPR when transferring data outside of the EU? This is a good question. Under ADPPA, actually, transfer means disclosure of data by transmission, regardless of whether or not the recipient is located in the United States, but there is no additional requirements for international data transfer as of now. Maybe they will see something with that in the future. There is another one about GDPR permits DPO to be employee or contractor. ADPP is only employee. So yeah, they are talking about qualified employee. That doesn't really specify what does it mean by qualified employees, but I know that it really means that someone needs to be aware of the regulation and it needs to be internally.
Yeah, so thank you everybody for attending today, and we hope to see you all soon. And we appreciate your time.
Have a wonderful day.
Thank you, everyone. Bye bye. See you.